Good morning, everyone. We're going to go on the record. Before we do, a couple rules this morning, giving the amount of observers. First, you are to turn off your device so you are muted and turn off your video camera. Second of all, there have been requests to record this proceeding. Those requests are denied. The rules, general rules of practice prohibit any recording other than the official record of the judicial branch, which is recorded by a certified court reporter. I imagine that transcripts can be available. That's under General Rule of Practice 42 or 4.02, Subdivision 5 at Prin 5. I need to tell everyone that a violation of that rule could lead to contempt proceedings. We are on the record in 34 CR 24.
For the record, I have an email.
And Madam Clerk, if you can disable that the buzzing or bell noise each time someone joins us, court would appreciate that. This is the state of Minnesota versus Nicholas Robert Rekieta. Am I saying that correctly? You've told me before.
Yes, sir, Rekieta.
I have your date of birth is December 16, 1981.
Yes, sir.
Currently reside at 12291. Okay. Your appearance today is based on 3 counts to a complaint order for detention. The record should reflect that Alex Kornahachi appears for the state of Minnesota. Mr. Rekieta, you are self-representing yourself at this point?
Yes, sir.
Okay. Count 1 is second-degree possession, 25 grams or more of cocaine or methamphetamine. This is in violation of Minnesota Statute 152.022, Subdivision 2, Prin A, Prin 1. The maximum sentence for that count is 25 years in prison and/or a $500,000 fine. Count 2 is possession of ammunition or any firearm with the user of controlled substances. This is a gross misdemeanor, so the maximum sentence is 364 days in the Kansas County Jail and/or a $3,000 fine. Count 3, endangerment of a child when present with a sale or possession of a controlled substance. Again, a gross misdemeanor. Maximum.
Get all your coke out, Nick, and kill yourself, you stupid motherfucker.
I'm going to warn everyone again, this is a court proceeding. If you were in a courtroom with me, yeah, would remove you. So any Judge, violation of that will be removed. Ms. Block?
Judge, I just disabled people the ability to unmute themselves, so I will work to unmute people as they need to speak to the court this morning.
All right, thank you. Aside from Mr. Rekieta and Mr. Kornahachi, no one needs to at this point. Lastly, I think I was saying that the count 3 gross misdemeanor has a maximum sentence of 364 days and/or a $3,000 fine. Mr. Rekieta, you understand what you've been charged with, and second question, the maximum sentences associated with each count?
Yes, Your
Honor. All right. Now, I don't mean to insult your intelligence, given you are an attorney, but it's important that I know that you understand your rights here. First of all, you are presumed to be not guilty of these charges. It is the state, not you, that has to prove what has been alleged in the complaint with evidence beyond a reasonable doubt. You have a right to trial by jury. All members of the jury would have to agree that the state had met its burden of proof beyond a reasonable doubt before you could be convicted. You have a right to counsel. You have a right to represent yourself, of course. If there's a trial, you could give your side of the story and testify, but you also have the right to remain silent. Indeed, you don't have to prove anything, so you don't have to say anything. If you remain silent, the judge can't make a comment about that. The prosecutor can't make a comment about that, nor can the jury take that into consideration. You have a right to confront, challenge, or cross-examine anyone who testifies against your interest. You have a right to call witnesses and the power of subpoena. You have a right to all of the state's discovery before trial, and including exculpatory information and evidence. And at the end of the day, if you think the court made some mistakes or a jury made some mistakes, you have a right to appeal. Any questions about those rights as I've explained them?
No, Your Honor.
This is a Rule 5 hearing. Sometimes we call it a bail hearing. We'll set this for a Rule 8 hearing. Under the rules, you have right to have that hearing within 14 days of today's hearing, but you could waive that as well, given your right to seek counsel if you so choose. Do you want this scheduled within 14 days, a Rule 8?
No, Your Honor, I'd like to waive that. We can combine it into a contested omnibus hearing. That would work.
All right, so we could, for today's purposes, combine Rule 5, Rule 8?
Yes, sir.
All right. And before you ask for a speedy, you want to hear what the state is requesting as far as release conditions?
Yes, I'd like to hear what the state is requesting.
I didn't say it, but you also have the right to have me read the complaint today.
No, I'll waive that right, sir.
All right, very well. Mr. Kornhachi, what is the state requesting as far as release conditions?
Yes, Your Honor. The state is requesting $50,000 unconditional. In the alternative, we would agree to RPR with standard drug conditions, which would include no use, random testing, no use and possession of firearms, contact probation as directed, don't leave the state without permission from the court, remain law-abiding, keep in contact with probation, and other standard conditions.
Mr. Rekieta, any objection to those conditions?
I object to the $50,000 bail. I think it's unduly burdensome and in violation of the 8th Amendment.
All right, what about the conditions?
Release conditions sound fine.
All right, the court will set unconditionally amount of $50,000, cash or bond. Conditionally, you'll be released in your own personal recognizance. In all instances, you need to be law-abiding and show up for all your court appearances. Conditions are as follows: abstain from the use of alcohol or any mood-altering chemicals not prescribed by your physician. That will be subject to random testing. So the court will order that you meet with probation upon your release, sign their agreement, and cooperate fully. You are not to possess any weapons, firearms of any nature, or be in the presence of anyone with a firearm or dangerous weapon, and do not leave the state of Minnesota without prior approval of the court. Any questions about those release conditions?
Yes, Your Honor. Did you say 50 or 15,000?
50000. 50.
Thank you, Your Honor.
Okay, let me ask this. Do you still want a speedy omnibus, or can it be scheduled in normal course?
You rescheduled in normal course, Your Honor.
Very well. Madam Clerk, do we have a date for that?
I'm sorry, Judge, I'm just going to interrupt. This is Katie Block, the court administrator. Do you want this next hearing to be in person or remote?
In person.
Thank you for the clarification.
Mr. Rekieta, you said contested, right?
Yes, sir.
Okay, so yes, in person.
And I'm sorry, Your Honor, just to clarify, timelines are waived?
Yes.
And Madam Clerk, just so the court is aware, Kristen Pierce is handling this case going forward.
All right, thank you.
You're welcome.
So while we're waiting for the date, $50,000 bond, cash or surety, which means he can
And the
pay.
matter has been assigned with Judge Fisher. I'm looking at Tuesday, August 20th at 2:45.
Good for the state.
Judge
Without
Fisher,
having a calendar, it sounds great.
Very well. Any other business we can conduct?
Now,
Yes,
on behalf of this,
Oh.
apologies. Go ahead.
Your Honor, I have requested to see two of my clients and have been forbidden from doing so. I would like to see them before their arraignment.
he's going to represent his
I'm not
wife.
understanding your request. Can you repeat it?
As two of my clients are set for arraignment today, I have requested to see them. They have both requested to speak to their attorney, who is me, and they have been prevented from doing so up to this point. I was wondering if we could get an order to allow me to at least speak to my clients before they come into their first appearance.
Gornahachi?
Your Honor, I'm not sure if the court is aware. April Multi has been released.
Okay.
And then I believe the other person who's referring to is his wife, Kayla. Is it Rekieta? Rekieta. I'll leave it to the court's discretion. They are charged as co-defendants. I believe she would have to waive any conflict, etc. But I don't take a position.
And to be frank, I don't know if that's a waivable conflict at this point, given they are co-defendants. But there's no request from the state that obviously they are married, so there's no request that they be separated. True?
Correct.
Well, it's an issue of denying counsel to Ms. Rekieta, so I will grant the request and leave that as an issue for Judge Fisher. At least to get us through the arraignment this morning.
Thank you, Your
Mr.
Honor.
Jailer, are you able to make accommodations? Mr. Rekieta, how much time do you need?
Not long, just about 15 minutes, Your Honor.
Can the jail accommodate that?
That'd be up to the jail administrator, Your Honor.
I'm sorry?
I would have to talk with the jail administrator.
All right. If they have any difficulties with that, the jail administrator, since I'll be in these proceedings, should contact Chief Judge Beckman.
Thank you, Your Honor.
Thank you. All right. Since Ms. Rekieta is not available, at least for the next 15 minutes, do we want to take the next matter?
Fine with the state, Your Honor.
Do we want to interpret the case next?
Which case?
The interpreter case?
Sure.
Okay, thank you, Your Honor.
Thank you, Your Honor.